Floss, subject lawyer, fighting for the Commonwealth, fighting for England, Scotland, Ireland, Australia, New Zealand, Canada, and America. And what is it that I'm fighting for? Well, I'm fighting for the right for us to be able to go to the court by ourselves without going through anybody else. You don't need to go through your MPs. You don't need to go through your parliament. You don't need to go through the Senate. You don't need to go through the police. What I'm trying to show you here is that you, every single one of you, has the power to enter the court and call these people into the court, and you run the show. You serve them. One of the things that you've got to get out of your head is that they serve us. They do not serve us. The only time they serve us is when they want to take money from us, or they want to put us into the prison for not paying the money that they've tried to take from us. So we do not want them to serve us. What we want to do is serve them. We serve them. We call them to the court about the exorbitant taxes. We call them to the court about the exorbitant rates and council taxes on your house. We call them to the court about spending all our money on wars that we don't support and on organisations that we don't support. The abortions, the homosexual movement, all of these things are all being paid for by you. So I want to show you how you serve them. And so I've gone to serve, so I'll get started because we want to make this a quick video. I'll get started. So I want to show you the progress of Kate Floss's case so far. Okay, so if you go to your Google, right, and then you'll see here, you just Google in like that. Look, you just Google in SIXT. My true name is Sixtus Verse. I have my stage names. My stage name is Kate Floss. My mother's name is Waterman. That's Caitlin Waterman. But my father's name is Sixtus. He was German, and a German slave brought to New Zealand in 1843. And so when there were certain agreements, I won't go there. Stay on the court, right? So go to your Sixtus Verse Adern, and then you click on there. You'll see all my court cases. So there's the courts of New Zealand Supreme Court. There is the New Zealand Law Society has picked up on my case, and they've been keeping an eye on things. We've got the Ministry of Justice over there. We've been in there since I actually went in at the end of 2021, and I'm still in there. I'm not out yet. This is the latest one, the New Zealand Supreme Court appeal. This is I'm going to go another time and show you what all these court cases mean. But this is Barnett that's picked up on my cases, and they cite all of my cases. And the newest one that we've got here is this one, Open Law, where I got my name up in lights. There's the Sixtus Pope, and it was a Sixtus Bishop that built the first Sixtus Cathedral. The first Catholic cathedral was built by a Sixtus Bishop who was not yet a Pope. So the Sixtuses were around long before Pope Sixtus I, Pope Sixtus II, Pope Sixtus III, Pope Sixtus IV, and Pope Sixtus V. That they said that there would never be a sixth Pope. Well, there may never be a sixth Pope, but there is going to be a sixth Sixtus coming into the courts, like Martin Luther of Germany, who rose up against the Catholic Church. Well, now we're rising up against many churches, many religions. We're rising up against the Judaism, the Muslimism, the Catholicism, and then we're rising up against the homosexual movement and all of these things that are causing chaos in our society. Everybody fighting for power, everybody fighting for money, and we're all just the little people stuck in the middle of all of this, and we've got to go to the court. Now, so this one here is called, this is New Zealand Law Society, who's put me in the courts roundup. So these are just all my cases. But the one that we'll go to is the Open Law, okay? So we'll go to the Open Law, I'll turn that one off, and we'll go to open law, which is here. So you just click on the open law. Now there's 3 cases in the open law. You'll see this one, Sextus versus Dern, New Zealand High Court. In the open law, they've only put in 3 cases. They put in, it's called the strike, the moot, and the oot. All right, the strike, the moot, and the oot. Now the oot means out of time, and the moot means a managed out of time. Now, they're not supposed to moot you before they oot you. You've got to be ooted first, and then they can moot you. And I'm going to explain the strike, the oot, and the moot to you. But this is the Sextus versus Ardern. And what you'll see here, this is the first case where we took Catherine Ann Sextus, Jacinda Ardern, Chris Farfoy, Andrew Little, Ashley Bloomfield, and we got struck out. And they put up the 4 prayers. These are the 4 prayers that now, when I wrote this, I'd never ever written a court document in my life. Another lovely lady had come in to help me write it, and both of us had never written a document like this, and we were walking in the blind. And so we did the best we could. I might change it a wee bit, if I were to rewrite it, but these were the 4 prayers. We did pray a declaration of the 1865-1908 Native Rights Act, and also we prayed for a declaration to bring back the ancient will of the 1688 Bill of Rights of the English speakers of New Zealand, all Europeans, and those things. I would have rewritten that a wee bit differently. I did pray for a declaration to clearly explain that the 1688 subject right under Almighty God exists, and that it was the all-powerful to overpower the 1990 Bill of Rights. Now, the 1990 Bill of Rights is an ordinary law. It was through this 1990 Bill of Rights that they brought in the Health Act. And when they brought in the Health Act, that was where they made all the lockdowns and all of the sackings and all of the injections that you had to have. So I had prayed under the 1688 Bill of Rights. That would have been a cruel and unusual punishment. It would have been a forfeiture of your person, and it would have been a subject's liberties to be allowed. It would have been an infringement on your subject liberties to be allowed. So I had asked the court for a declaration to say that the 1688 was the supreme law under Almighty God, and that overpowered any laws that were repugnant to it coming out of the 1990 Bill of Rights. Now, I'm not going into the prayers. There are other prayers there. But anyway, we also, as part of the case, we had put in the grievances that we had had, the closing down of the New Zealand Marsden Point oil refinery, the entry of the government into the United Nations Declarations of Indigenous People, the 3 waters where they were stealing the resources of water from the New Zealand people and putting it into the hands of a few elites. The allegations that were made by Judith Collins was this thing called the He Puapua, where they wanted to put all New Zealanders under this quasi-constitution that they'd made, and they were trying to get us all under that, a bit similar to the Voice over in Australia. They wanted to have a 50% unelected Maori parliament, which it starts out as New Zealand Maori, but as soon as they get the New Zealand Maori, they tag on and Pacifica, then they tag on and ethnic people, then they tag on and disabled people, then they tag on and then they all want a separate little parliament of their own, and of Jewish people, and of Muslim people. They all want their own little separate parliament, and they want to take all the funds from all of you people and divide it up into their own separate little parliaments that they want to have, and they want to live in closed off areas across the country. They want to do this in Australia. They're doing this in Australia, over in England. They want to have closed off areas across the country, and each area will be a designated parliamentary area where they'll have their own money, their own parliament. All right, so one area will be for Muslims, one area will be for the Jews, one area will be for the homosexuals, one area will be for the refugees, one, and so on and so on. And as long as they've got enough people in an area, they take control of that entire area, and your country is going to become extremely, extremely disjointed. So this is where they're going. The next one. The allegations concerning the health system, 2 Mormon temples which were endangering the Protestant religion. Now, it's not just the Mormon temples, because down in Wellington, they want to have the Muslim calls to prayer every morning at 5 o'clock in the morning. They want that the call to prayer to go out across all of Wellington, and that sound is going to go right over to Picton. That is actually a claim over your country. Now, they want to, over in England, they've got Rishi Sunak, who is flying the Pakistani flag at Westminster. He also is demanding that the diamond from the crown be shipped back to India in this Quakamami quasi oral tradition that the diamond belonged to them, when in fact there's no evidence that it ever belonged to them. So it's been held by the Queen all this time, and Rishi Sunak is sending it back. Then we've got over in America, we've got Trump building the embassy in the middle of an American embassy in the middle of Jerusalem. So they're all up to a lot of. Over in New Zealand, we've also got the biggest Indonesian Hindu temple being built in the Aimahutu stone fields. That's a whole nother story. Pania Newton set all that up. And then we've got some various other things on there, but that's not what we're talking about today. So this is the first case, and then the judge struck me out. Now, what you'll see when you read this is that he only put up the prayers that we were asking for a declaration to affirm the 1688 Bill of Rights under Almighty God as being the supreme law, okay? But he did not put up the causes. Now, I'm not going to tell you all the causes today, but I will tell you one of the causes. One of the causes was in the Human Rights Act. One of the causes was that in the Human Rights Act, under Section 5, subsection 2, KII, it's got in there that it is the desirability of New Zealand becoming bound by any international instrument on human rights. Now, a lot of you don't know. Now, this is the problem here. Australia, Europe, England, you don't understand that we've got this thing called the Treaty of Waitangi in New Zealand. And what you don't understand is that Australia and all of Europe are in that Treaty of Waitangi. Now, that Treaty of Waitangi has been put into the Human Rights Act, and that Treaty of Waitangi has been completely changed. They wrote behind our backs a brand new treaty, all right? And then part of what they put in there was that it was the desirability of New Zealand becoming bound by any international instrument on human rights. Well, once that gets done in New Zealand, that will go over into England, that will go over into Australia. You really have no idea how bound to New Zealand you all are. You all think that England is the big hoo-ha, but I'm telling you, it's not. The Holy Land is in New Zealand. New Zealand is the Holy Land, and the Holy War is being played out in New Zealand right now as we speak. So I put in to the prayer, as you saw from the prayer that I just put in there. I think I've closed it down now, but have I closed it down? Oh, what a pity. I'm not supposed to close that down. But you can see down here from the prayers anyway, it was quite a long document. You can see down here from the prayers that we did pray for a declaration to the effect of clearly stating the applicant's ancient 1688 subject's right under Almighty God, and that it exists. And we wanted that to overpower that clause number 3, section KII. Oh, now I've got to find it now. Was it in clause number 2, I think? Okay, so that's going to counteract this Human Rights Act, the desirability of New Zealand becoming bound by any international instruments. Now, I want you to keep an eye on this because I'm going to show you something. So, I'll just put in Sixtus verse Undern, get that one back. And we can go down to the open law. There's many open laws, but the first one is the strike, which is the 116, Sixtus verse Undern. Now, what I want to show you here is in that case, they cited Arthur Taylor against the Attorney General against Arthur Taylor. Now, as I just told you, section KII, where they're bringing in the United Nations, all their thousands and thousands of laws guaranteeing refugees the right to a house, guaranteeing refugees the right to a job, guaranteeing refugees the right to equal pay, guaranteeing refugees the right to their own ministries. That all comes through the United Nations, and this is why you have got no power. But if you look here, and so this is what it's a very big thing. Now, if you look here, this case here, this was the case that I had cited in my case and I had opposed. And this man here, Arthur Taylor, look at all of the citations. Usually you'll get 1 or 2 citations per case, but he has been cited by dozens and dozens and dozens of cases. And this is all the legislation that has come about through his Human Rights Act of 1993. Now you'll see how they're infusing. They have connected this Human Rights Act up to the Declaratory Judgments Act. Now that's a whole nother story. This Declaratory Judgment Act was written specifically for our 1688 Bill of Rights, all right? I'll do this in another video at another time. But you can see that they've gone and removed our 1688 Bill of Rights and they've linked it up to this New Zealand Bill of Rights Act. And they've linked it up to this Human Rights Act, all right? Now, our Bill of Rights, our 1688 Bill of Rights is not an act, it's a constitutional law. And then you'll see that they've bound these up. Then they bound it up with the electoral law, 1993. I'll come in and I'll show you the problems with all of these laws, so another time. And then they've bound it up with the Judicature Act, and then they've bound it up with the electoral law, the Interpretation Act, right? Then they've bound it all up together with the Crimes Act. Then they've continued to bind it, and then they've bound it up to the Constitution Act. Then they've bound it up to the Criminal Procedure Act 2001. Then they've bound it up, Constitution Act, then Crimes Act. Then they've bound it all up, Human Rights Act, Constitution Act, and then that's all. So what you'll see here, if you know what you're looking at, which I do, they've got all these people, all these independent people. I will say the word allegedly, I will allege. Sue Gray, I will allege Arthur Taylor, I will allege several other people who knowingly or unknowingly, whether they have been led by their law firms or whether they have been ordered to, I don't know if they are knowingly or unknowingly. But what I do know is every time they file a court case, they were using the 1990 Bill of Rights and they were using the Human Rights Act 1993, and they have linked up every single one of our constitutional laws. Now, this Declaratory Judgments Act, right, and then this Judicature Act of 1908 and the Declaratory Judgment Act of 1908, they were specifically written for this 1688 Bill of Rights. And this is, now, this, I'm not going to go into these rights today, but this is a right. What is different? Because this is a right that is specifically, it says that the Prince and Princess of Orange, it doesn't say that they are your rulers. What it says is that the Prince and Princess of Orange, whom it has pleased Almighty God to make the glorious instrument of delivering this kingdom from popery and arbitrary power, which means that this Bill of Rights here, it's called the Borns, B-O-R-N-Z, Borns, and the other one is called the BORA, B-O-R-A, which is the Bill of Rights Act, and then the Bill of Rights New Zealand, 1688. So these are not, this is not an act. So this one here, you'll see here, it's not an act, whereas that 1990 is an act. So that, I'm not going to do this today, but that declaratory judgment and 1908 and that Judicature Act of 1908, both of those were written specifically for this under Almighty God, and this is what they're trying to wiggle their way out of. And old Kate Floss saw it for what it is, and Kate Floss went into the court and called them out. Now, getting back to where we were, over here, so at this point, Judge Cook struck out the case, right? And over the last 2 years, I have been appealing. I appealed to the appeals court. The appeals court said that you must come in, and then but the appeals court said, Jacinda, these were the people that we called in, which were Jacinda Ardern, Chris Farfoy, Andrew Little, Ashley Bloomfield. They were the ones that were called in, and then the court. I originally came in with 2 people, but one of the person dropped out at the very, very beginning. They dropped out, so I've been doing this on my own. Now, now, where was I going to say there? Now, this case here, I got struck out, and then when I went to the 4 respondents, Jacinda Ardern, Chris Farfoy, Ashley Bloomfield, and Andrew Little had refused to come into the court. Well, the appeals court said, you must come into the court, right? But when they said you must come into the court, the Crown Law said, we will come to court if you pay us $10,000. So for 2 years, I've been saying to them that they must come into the court, but I don't want to pay the $10,000. Now, what had happened was I ended up going into the Supreme Court where I was opposing. Now, it gets a bit confusing here because this here was a case here with, this was the judgment of Brown and Katz. All right, I had applied for, I don't know how to explain this to you. Right, calm down. Go slowly. Right, so the appeals court ordered the 4 respondents to come in. Then they asked for $10,000. I appealed that, the registrar's decision, or I applied for a fee waiver, and the registrar denied the fee waiver. I appealed the registrar. That went to Judge Brown in the appeals court. Judge Brown stood by the registrar and said, Kate Floss, you have to pay. So I appealed that to the Supreme Court, all right? Now, over in Supreme Court, I got into a little bit of trouble, and I was over in Supreme Court battling Judge Brown, okay? I was over in Supreme Court battling Judge Brown, okay? And then the case over in appeals ran out of time. When the case over in appeals ran out of time, I put that under appeal to get it back into time. I'd run out by 1 day. While that was still being decided, that was called the OOT, O-O-T, out of time, the OOT. While that appeal was still ongoing in the appeals court, the Supreme Court said, oh, this is out of time already, so we're going to moot this case against Judge Brown. And they wanted me to pay, I had to pay $1,000 to get in the court and $1,000 in costs. So this case here, many of you try to get it. This case here is versus Jacinda Ardern, Chris Farfoy, Andrew Little, Ashley Bloomfield, where I had appealed the decision of Judge Brown to force me to pay the $10,000 and the court fee of $1,000. I had said that I didn't want to pay that, and I wanted to go to court anyway. So I appealed that. Over in Supreme Court, they mooted the case. But when they mooted it, all right, in an actual fact, the appeal of the out of time was ongoing. And so that OOT was still going right up until October 2023, where I lost the OOT. And it was the same Judge Brown and Katz, where they did not accept my case of being out of time. So it was Brown J that did not accept my appeal against the registrar for fees, and then it was also Brown J that did not accept my appeal of the out of time, the OOT. Now, if we were strictly speaking, I have now appealed the OOT because I have said that they should not have mooted me, because they mooted me before the OOT. Well, everybody knows that OOT, O-O-OOT, comes before OOT, moot. It's OOT, isn't it? Because you know the OOT, but OOT, boot, OOT, foot, OOT, hoot, all OOT, loot, OOT, moot. So the OOT comes first. You cannot have a moot without the OOT. So they mooted me. So when you go to here, hopefully you'll all understand, because look here, this is cos J, here is the moot. There is the moot, right? And look at the date. The moot is on the 12th of July. They said that your case is no longer extant. They said the applicant's substantive appeal in the Court of Appeal is no longer extant, having been abandoned, which I never abandoned. It was not abandoned. It got out of time by 1 day. It got abandoned, they said, and so therefore they mooted me. But in fact, I appealed the oot, and the oot was ongoing, so they should not have mooted me. So you can see the date on there. They mooted me in Supreme Court on the 12th of July, and yet they did not, the oot did not get completed until October 2023. So these 3 cases, this is how you'll see them. Okay, this is what you'll see. You'll see the strike, and then that's got the 4 prayers, and it's also got the grievances, and all of those have been fixed now, right? And then secondly, they mooted me. So there is the moot, right? And there's the moot there. So they mooted me, right? And then after they mooted me, they then ooted me. So it's up the wrong way. It should be strike, oot, and moot, not strike, moot, and oot. So there you go. So what I have presently done is I am appealing the oot. And if the oot is successful, I will then be able to go back and reinstitute the moot case. So whoever can follow that. Now, I'll just put this up here for everyone to see. Please donate. Kate Floss, donate. ASB, Australia, ASB Bank of New Zealand comes under CM Waterman 123167 0101-13050. This is the most important case. It's a holy war going on right in the courts right now as we speak. If anyone wants to donate for Kate Floss, I know a lot of people are asking for donations, but you have to ask yourself what these donations are going to do for you. What it's going to do for you is to teach you how to go to the court and file cases by yourself so that you can take the power back to yourself. It's all about learning. You have to relearn how to go to the court by yourself. You cannot rely on Parliament anymore. You cannot rely on voting anymore. You cannot rely on any of these things anymore because they are just going to do whatever they like. The only course of action, the only remedy for you is to go into that court and file your own case against the court. And Kate Floss is going to teach you how to do that. And if we all go to the court with our 1688 Bill of Rights, if we all learned how to do that, we're going to get everything back into check again under the holy almighty God. And everything's going to set right, okay? They'll no longer be able to charge you all these monies. They'll no longer be able to force you off your properties. They'll no longer be able to charge you exorbitant rates of thousands and thousands of dollars so that you can't even afford to pay and you lose your home. That's another story. So don't forget to donate to Kate Floss. I'm doing a lot of hard work here for you, okay? So anyway, moving on from there. I currently will show you that I have gone into the court and I got I did get a letter from the court, and it says here on Wednesday, 21st of February. So I'm appealing the oot now. That's what I'm appealing is the oot, okay? So the oot's been appealing. So 21st of February 2024, Catherine Ann Sextus, that's me, Kate Floss, filed the application for leave to appeal against the judgment of the Court of Appeal, which was delivered on 26th of October 2023. That is the oot, or the abandonment that they said, or the out of time. So I'm appealing that. So then it said I acknowledge the receipt for leave to appeal to the Supreme Court, Catherine Sextus versus Jacinda Ardern, and I had to file 10 pages by Wednesday, the 20th of March, is what I had to do. And the respondents must then file and serve written submissions of not more than 10 pages in length within 15 working days of receiving the applicant's submissions. So I have put mine in, so then I got the next letter from the court, which is, so I had 20 days, after paying the $1,000, I had 20 days to file my submissions, and my written submissions, so I've done that. Then after that, they have 15 days. So now they've said the applicant's submissions for the above application for leave to appeal were filed on Wednesday, 20th of March. The respondent's submissions in reply of not more than 10 pages to be filed by Friday, the 12th of April. So we're waiting for the 12th of April, where the court is going to get the submissions of Jacinda Ardern, Chris Farfoy, Ashley Bloomfield, and Andrew Little. Now, after that, the written submissions of each party presented by counsel, we are supposed to provide an indication of the counsel's preferred dates for the hearing of the appeal in the event that leave is given. So leave has not been given just now. We got to wait for them to put in their 12 pages, but they said that I was not allowed to make an oral submission, but me being Kate Floss, I decided to ask the panel of judges if I could have an oral submission. So it says here, now where's my oral submissions? So I had, so I sent them a letter and I said, know ye all men, attached is a written indication of the person, that's me, because they said to me only a group can apply for a fee waiver, but I said the person in a private prosecution should be permitted to apply. To provide preferred dates of the appellant, know ye all men, attached is a written indication of the person to provide preferred dates of the appellant to all persons of interest to attend the hearing of an appeal in the event that leave is given. And then I said to them, this train is a clean train. Stop your cheating and your lying and your corruption. And this train is bound for glory. That's because I'm bringing the Almighty back to the Supreme Court. I'm bringing the Almighty back. I'm raising him up to head the country, head our countries, to take over our countries. No foreigners are allowed to be in our parliaments. Rishi Sunak, you are not allowed to be in the English Parliament flying a Pakistani flag. That is treasonous right there. That is absolute treasonous. And Lama Omar over in America is just getting thrown out now for flying Somalian flags and going around telling the Somalians that she's running this, doing all sorts of things. And they've said to her, you are allegiant to a foreign power. And Rishi Sunak, when you put that flag up, the Pakistani flag up at Westminster, allegedly, it has been put up. That's treasonous. And if you allowed that to happen, it doesn't even matter if you didn't allow. You're the Prime Minister, Rishi Sunak, and it should never have happened. You should be stepped down right this minute for allowing a Pakistani flag, a Hindu Muslim flag, to be flown above Westminster in place of the Union Jack. Now that is just absolutely shocking. So now I've said, so know ye all men, attached is a written indication of the person to provide the preferred dates of the appellant to all persons of interest to attend the hearing of the appeal in the event that leave is given. This train is bound for glory. Your petitioner will ever pray. Now, when you use this 1688 Bill of Rights you're praying. It's a prayer, and this is the only document in the court that you're permitted to use, and you're permitted to use the vocabulary of it, which uses vocabulary that is straight out of the Bible. Straight out of the Bible, and you can use it right there in your courts, and that's going to bring the Protestant and Martin Luther of Germany. It's going to set it all right. So then I did put in my own little thing here. This one's for me. This is Kate Floss. Sometimes I like to have a bit of fun. I've put the Battle of Kate, the right to petition, that it is the right of the subjects to petition the king, and all commitments, that's all fees, and all prosecutions for such petitioning are illegal. That's what I'm saying to them. I don't have to pay you $10,000 because all commitments, when you petition the king, if the parliament has gone rogue and you're petitioning the king, you shouldn't have to pay for that because you're going to the court for protection, and it's a protection order, and all protection orders are free. All protection orders are free. And then I said to them, I have the honour to acknowledge receipt of your letter of 25th of March, that the written submissions of each party represented by counsel or represented by own person must provide an indication of the preferred dates. I do pray that the Supreme Court may grant an oral hearing to this request of a declaration of right by this petitioner, Catherine Ann Sextus. The preferred date of the petitioner is the month of May, dates 20 to 24 in the year 2024. Now, this is a very auspicious, because the 24th day of 1820 of May is when Queen Victoria was born onto this earth. So I put those dates up there. Seeing that the Treaty of Waitangi, the preamble. Now, I'm going to do another video on this treaty for all you Europeans that Europeans and Australians don't understand that you are in this treaty. You don't even realise how deeply you are involved with this treaty, and it's this treaty that's just on the precipice of falling into the abyss forever, and we don't want that to happen. The subjects of Her Majesty Queen Victoria of the United Kingdom of Great Britain signed 184 years ago, and ordinances of the German people signed 180 years ago, safeguarded for all time the rights and privileges of the subjects by oath to the Majesties, in honour of Her Majesty Queen Elizabeth II and His Majesty King Charles Rex III. Your petitioner therefore prays that an oral court hearing at this Supreme Court in honour of the Treaty of Waitangi and oaths be embodied in the statute records of New Zealand, in order that all may know that the Treaty of Waitangi is operative through the oaths and the Bill of Rights 1688, also to preserve the ties of brotherhood between Pākehā and Maori for all times. Your petitioner will ever pray that you, the Supreme Court panel, and respondents, Jacinda Ardern, Chris Farfoy, Ashley Bloomfield, and Andrew Little, will consider and give effect to this request. And these are the people that I've asked all to come to meet me in the court. The Honourable Crown Lord Peter Gunn, Dame Jacinda, Kate Ardern, and Chris Farfoy, Andrew Little, Ashley Bloomfield, the Appeals Court Registrar, the Appeals Court Judges, Brown and Katz, the High Court Registrar, and the Honourable Justice Cook. Now, all of these people that I've named on here, you can see that they've all been named here by the court. So this is from the Registrar of the court, who has already sent copies to all of these people. Now, why is the Supreme Court sending copies to all of these people? I believe, and as you all know, I'm just Kate Floss, a subject lawyer, and I'm not a lawyer at all, and I'm just a person living in my heavenly space. But these are all for entertainment purposes. I absolutely do not have any law degrees, and you cannot believe any. You have to go and research yourself and ask a lawyer. But these are the things that go on in my mind. But anyway, to my mind, these are all being given notice and sent copies because they may or may not be called into the court, or they may or may not be mentioned within the court proceedings. So because of that, the High Court, the Appeals Court, all the registrars, all the respondents, because I asked for a certity or irari, all of them have been given notification of what's going on. So that's why you'll see when I was asking for the dates of the 20th to the 24th of May, that I had put all of these names, because these are all the people that are on the court's list already. Now, I'm going to be finishing up, but you'll see this signature. This is Tahupotiki, Wiremu, which is William, Ratana. And where did I get most of this here? Is actually come from an ancient petition that was put forth in 1932. So I'm not the first one that has petitioned to the court, although he did not mention the 1688 Bill of Rights. He has mentioned that seeing that the Treaty of Waitangi was signed 92 years ago. So now we're doing that it's been signed 184 years ago. So he said it was signed 92 years ago by New Zealand's first governor on behalf of Queen Victoria. And the leading Maori chiefs not only established British sovereignty in this dominion and laid the foundation of its peaceful settlement and ordered government, but also and its peaceful settlement and ordered government, but also safeguarded for all time the rights and privileges of the native race. But it also, by our oaths, gave us our rights and privileges as well. The site of its execution cannot fail to be an object of considerable interest both to New Zealanders and to British visitors in days to come. If this is so, its preservation as a national monument would appear to be desirable. Your petitioner therefore prays that the Treaty of Waitangi be embodied in the statute book of the Dominion of New Zealand, of the Dominions of the British Commonwealth, and of the British government respectively, in order all may know that the Treaty of Waitangi is operative, also to preserve the ties of brotherhood between Pākehā and Maori for all times to come. Your petitioner will ever pray that you, the Speaker of the Honourable Members of the House of Representatives of New Zealand, consider and give effect to this petition. Your petitioner will ever pray. So we've put that up there, but in the actual one, my signature is right on next to his signature. So I borrowed a wee bit from Ratana, and so thank you so much for that. And in an actual fact, what a lot of you do not know, I'll leave that out for later. Okay, so what a lot of you don't know is that Queen Victoria was German, and Queen Victoria brought down the German king. Now, that's a whole nother story, but it may be that we don't want to be subjects. What they did was they brought German people out. They purchased German people out of Germany and brought them to New Zealand, and they got all of them to be the first people to oath to Queen Victoria. And by oathing to Queen Victoria, that is what cemented the Treaty of Waitangi into place, was the oaths. If you don't have a subject, you can't have a treaty. And what they needed was people that were not subjects of England. Now, they brought thousands of Europeans who were not registered citizens. They were native people of Europe. They brought them from Austria, they brought them from Prussia, they brought them from Russia, they brought them from Hamburg, Germany, they brought them from Norway. They all had to be people that were not registered as subjects or as citizens. They were natives to the land, and they actually purchased them from Europe and brought them over, and they made them subjects when they arrived in New Zealand. And those people, without those people, the treaty would never have come to pass, and we would not have our subject status. Now, a lot of people don't want to have subject status. They want to go back to the allodial land, but that's a whole nother story there. But the fact of the matter is, presently, we need this 1688 Bill of Rights so that we at least have the right to go to court, to fight for our lands, because your property rights and your rights to be in control of your government, that's all in the 1688 Bill of Rights, and that's what they're trying to remove from you, that power that you have. Now, you might not want to be a subject at a later date, but presently, this is where your safety is under Almighty God. So, remember, that's all. I'm going to wrap this up now, but, so remember, any of yous out there who are following my cases, if you want to put in a donation for Kate Floss, it's Kate Floss Donate, ASB, which is the Australia something Bank of New Zealand, and it's the ASB New Zealand. Unfortunately, if you're outside of New Zealand, I wouldn't even know how you donate to that, but I go through the Western Union, so I'm pretty sure if you're overseas, you can go to the Western Union, and there is my bank account, 12316701013050. If you do send me a donation, you can send me a note, and I'll go and check that it went into the account, and I'll be able to give you a little warm mussy on my channels. I do have one special donor. I don't never mention names, but I do have a special couple of donors. But I've got one very special donor who's donated a lot, many times to me, and he is really that person. I won't mention names, but I just want to say the biggest thank you in the world. You have saved me so many times. There have been times when I've paid court fees or I've paid lawyers' fees, and I've had to, my son has not been able to go to his dentist appointment, or we've not been able to eat well for that week, or, there's just all, even though I have paid it, or I've had to work extra hours in order to make up for the money that I've had to spend. So I have got a very special donor who's been lovely, and I just want to say a big thank you. I'm sure that that person knows who they are, and I just want to say thank you very much, and to all of the viewers. And remember to, I don't like to end on that. Can you please remember to like, and just subscribe to Kate Floss. That is very, very important that you, it's very important that you like and subscribe to Kate Floss's YouTube channel, because we've only got, I've got 766 subscriptions, but if I get 1,000, I'm allowed to go live, and I'm allowed to share screen on the livey, and the YouTube people will come in and help me to jazzy up my show and everything. So we'll get famous then all around the world. So if you could just if you could just like and subscribe and help me. If you can't donate, then the other way that you can help me, there's many ways to help people. The other way you can help me is to share my cases, or even just get your family members to come in and like and subscribe so I can get it up to 1,000 viewers. Kate Floss, citizen, journalist, citizen, lawyer, citizen, save New Zealand, save England, save Australia, save the Commonwealth, and get those Pakistani flags down from Westminster and get that Union Jack back up again. Save the Union Jack. Save New Zealand, save the treaty, save our 1688 Bill of Rights, which is so important to you. You have no idea how much this document is going to save you. That's our 1688 Bill of Rights. That's where it's got, see this one here, it's got your freedom of speech. This has got your levying of money. The levying of money. The levying of money for or to the use of the Crown by pretence of prerogative, without grant of Parliament, for longer time or in other manner than the same is or shall be granted, is illegal. That means when you vote them into Parliament, they're supposed to have a portfolio. This is what they're supposed to do. They're supposed to see when they have. I'll just give me 2 more minutes. When they have these elections, right? When they have these elections, they're supposed to provide you with a portfolio of the things that they're going to do for you. And then you vote for them based on that portfolio. Now, what they're doing is that they give you this beautiful portfolio. When they get into Parliament, they turn around and spend all the money that you said to them that they could spend on something that's not in their portfolio. Now, that is called a levying of money for the use of the Crown by a pretense of a prerogative, that they're saying, I've been given the mandate and therefore I can do anything I like. Well, that is not true. If it wasn't in the portfolio, they're not supposed to do it. It would be when you go and you want to build your house, right? And you go and see the contractor and you say to the contractor, I want this. The contractor says, you say to the contractor, can you design it for me, please? He says, right, I'll design it. He comes in, he gives you a beautiful design. He says it's going to cost you $500,000 to get this design, right? Halfway through the design, you've already paid him. You've paid him $400,000. You're on the last $100,000. Do you know what he does? He comes in and he changes the design. He adds all this stuff. He takes away all this stuff. The project is only half finished. And he says, if you don't give me another $1 million, I'm not going to finish this project. Not only am I not going to finish this project, I want to add all these things on. And you say, but I don't want those things. And he says, well, if you don't give me the money for those things, I'm not going to finish the project. And the whole thing's going to fall apart. You are up the creek without a paddle. Well, this is what these politicians are doing. They're giving you a portfolio. They're telling you what they're going to do. When they get into Parliament, they are completely changing it. And they're taking all your money and they're spending it on things that they shouldn't. That's called a levying of money. A levying of money for the use of the Crown with the pretense of the prerogative, without any grant of Parliament. The grant of Parliament is the portfolio that they got voted in on. That is the grant of Parliament, that we granted them the right to spend our money for those things. So then you've got your right to petition, which is the right that when they start spending all your money on all these nefarious projects, all these wars, $3 million to the Israeli war, $3 million to the Ukrainian war, $3 million to the Palestinian war. And you know what? They've got all their cronies over there. That money leaves the country and you don't know where it's gone. They've got all their companies set up over there, and they are just milking them and milking them of all this money. That's what they're up to. This is a levying of money without our consent. Now, not only that, now here are your property rights, that all grants and promises of fines and forfeitures of particular persons before conviction are illegal and void. Now, the grant, when you go and purchase your property, you're given a land grant, and that is protected by the king, right? And they cannot forfeit your property without a conviction, so your property is safe. But what are they doing? After they get into Parliament, they are increasing your rates or your housing tax. Your housing tax on your house goes to such an exponential level that you're not able to pay that. That gives them the ability to give you a conviction for not paying your money, and that gives them the ability to forfeit your land from you. So forfeiture of person without conviction is the protection of your land rights right there. So this is a very, very important document. That's all from Kate Floss. I'll see you later.